We have word that the Supreme Court has issued a ruling on the extent of presidential immunity from criminal prosecution for conduct alleged to involve official acts during the tenure of President Trump.
Okay, so picture this. You're Donald Trump. You're sitting in the White House, President of the United States for the second time. You've survived impeachments, investigations, indictments, all of it. And the one legal shield that's kept you out of prison is presidential immunity. The Supreme Court basically said back in 2024 that presidents have broad immunity for official acts. That ruling saved you. It stopped the criminal trials. It gave you breathing room. It let you run for president again and win. And now, October 2025, you're thinking you're untouchable. You've got immunity. You've got power. You've got control. And then boom, the Supreme Court drops a decision that changes everything. 5-4. They strip your immunity. They say it doesn't apply to personal or political actions. They clear the way for every single criminal trial that's been sitting on hold to move forward. And just like that, your entire legal strategy collapses. Your last line of defense is gone, and the trials, all of them, are coming back. But before we go any further, real quick, let's be honest, you can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us. Be part of the community that actually cares about the truth. All right, let's get back to the video. This actually happened October 21st, 2025. The Supreme Court releases a decision that effectively ends Trump's presidential immunity defense for criminal prosecutions. And I'm not talking about some minor legal technicality that only lawyers care about. I'm talking about the thing that's been protecting Trump from federal criminal trials for over a year. Gone. Wiped away. The court ruled 5-4 that immunity protections do not extend to actions outside the scope of official presidential duties. Which means if Trump did something in his personal capacity or in his political capacity as a candidate, he can be prosecuted for it. No immunity, no protection, no shield. And here's the kicker. This decision came after an emergency review. The court didn't wait for its regular schedule. They fast-tracked this, which tells you how serious they thought the issue was. Lower courts had been challenging the original immunity ruling. Judges were basically saying, wait a minute, this can't be right. You're telling us a president can do literally anything and claim it was an official act? That doesn't make sense. That's not how democracy works. So the Supreme Court took another look, and this time they came to a different conclusion. The majority opinion, released on October 21st, is pretty clear. It says a president, current or former, cannot invoke immunity as a sword to obstruct criminal accountability for acts undertaken in a personal or political capacity. Cannot invoke immunity as a sword, that's strong language. That's the court saying you can't weaponize this protection to avoid prosecution for crimes. And that's exactly what Trump's been doing. He's been using the immunity ruling to block every criminal case against him. Election obstruction, that was official acts as president. Classified documents, that was official acts as president. Trying to overturn the 2020 election, official acts, everything was official acts according to Trump's lawyers. And for a while, it worked. Courts were reluctant to move forward because the Supreme Court's 2024 ruling was so broad, but now that's over. The courts clarified the immunity only applies to actual official duties, not personal stuff, not political stuff, not criminal stuff disguised as official business. And according to Reuters, reporting on October 23rd, federal judges have already started scheduling trials. Trump's election obstruction case, that's resuming in district court in early December, 2 months from now. The classified documents case in Miami, that's starting in February 2026, which means right as we're heading into the final stretch before the midterms, Trump's going to be sitting in criminal court facing federal charges as a sitting president. Let that sink in. A sitting president on trial for federal crimes. That's never happened before, not in American history. We've had presidents investigated. We've had presidents impeached, but we've never had a sitting president actually standing trial in criminal court until now. And here's what makes this even more insane. The New York Times reported on October 21st that part of what triggered this Supreme Court review was the revelation that Trump's DOJ sought $230 million in personal compensation for legal fees related to these immunity cases. $230 million. Trump wanted the Justice Department to pay him for his legal defense using taxpayer money to defend him in criminal cases. And critics are saying that right there proves he's abusing executive privilege, because if these were truly official acts, the government would already be covering the legal costs. The fact that Trump's demanding compensation suggests even he knows these weren't official acts. They were personal, they were political, and now he wants taxpayers to foot the bill. Bloomberg Law reported on October 23rd that this decision is already having ripple effects. A New Jersey congresswoman tried to cite the Trump immunity precedent in her own criminal case. She basically said, if Trump gets immunity, I should too. And that argument apparently helped push the Supreme Court to clarify their ruling, because they realized, oh, if we leave this too broad, every politician is going to claim immunity for everything. We need to narrow this. We need to make it clear that immunity is limited. So in a weird way, some random congresswoman's legal defense strategy helped bring down Trump's immunity shield. And now we're here. Supreme Court strips Trump of immunity. Criminal trials moving forward. A sitting president about to face prosecution. And the 2026 midterms looming over everything. This is not just a legal story. This is a constitutional crisis, a political earthquake, and a preview of what the next year is going to look like. Chaos. Pure chaos.
Court has rejected Donald Trump's claim that he is immune from prosecution in the 2020 election interference case against him.
So let's break down what this decision actually means, why it happened, now, and what comes next. Because this story, this is the one that changes everything. All right, so let's rewind and understand how we got here. Because the Supreme Court doesn't just randomly reverse course on major decisions. Something had to trigger this. And that something is a combination of lower court pressure, abuse of the original ruling, and the political reality that even conservative justices realized they created a monster. Back in 2024, the Supreme Court ruled in Trump v. United States that presidents have broad immunity for official acts. That case came up because Trump was facing criminal charges for trying to overturn the 2020 election, and his lawyers argued that everything he did was in his capacity as president, therefore immune from prosecution. And the Supreme Court, in a controversial decision, basically agreed. They said presidents need immunity to do their jobs without fear of politically motivated prosecutions, which sounds reasonable in theory, but in practice, what it meant was Trump could claim literally anything was an official act and therefore immune, calling state officials to pressure them to change vote counts, official act, organizing fake elector schemes, official act, taking classified documents to Mar-a-Lago, official act. Everything became official in Trump's legal arguments, and for over a year, it worked. Federal prosecutors were stuck. They couldn't move forward with trials because Trump's lawyers would just say immunity, and judges didn't want to violate a Supreme Court ruling. So everything got delayed. Cases sat on hold. Trump ran for president again, won, and suddenly he's back in power with all these criminal cases frozen in legal limbo. But here's what Trump and his lawyers didn't count on. Lower court judges getting frustrated because judges don't like being told they can't do their jobs. And what the immunity ruling effectively did was tell judges, you can't hold presidents accountable for crimes, even if there's evidence, even if there's probable cause, even if a grand jury indicted them. Just hands off immunity. And a lot of judges, even conservative ones, started pushing back. They started issuing rulings that questioned the scope of the immunity decision. They started asking, okay, but where's the line? What counts as an official act and what doesn't? Because if we say everything a president does is official, then we've basically created a king. And America doesn't have kings. We have presidents who are supposed to be subject to the same laws as everyone else. So lower courts started chipping away at the immunity ruling. They issued narrow decisions that said, well, maybe this specific action wasn't official, maybe this was political, maybe this was personal. And slowly, the legal foundation of Trump's immunity defense started cracking. Then came the $230 million bombshell. The New York Times reports on October 21st that Trump's DOJ filed a claim seeking massive personal compensation for legal fees related to the immunity cases. $230 million. Now think about what that means. If Trump truly believed everything he did was in his official capacity as president, the government would already be covering his legal defense. That's how it works for actual official acts. If you get sued or prosecuted for something you did as part of your job as president, the government pays for your lawyers. But Trump wasn't asking for the government to pay his lawyers. He was demanding compensation after the fact, which suggests his lawyers knew these cases didn't qualify for government-funded legal defense. They knew the immunity argument was shaky, so they figured, let's just demand money instead and see if we can get it. And critics jumped all over this. They said, this proves Trump's abusing executive privilege. He's trying to have it both ways. He wants to claim immunity from prosecution by saying everything was official, but then he also wants to get paid personally for his legal defense because he knows it wasn't actually official. You can't do both. Either it was official and the government covers it, or it was personal and you pay for it yourself. Trump's trying to claim both simultaneously, which is absurd. And that revelation apparently played a role in pushing the Supreme Court to take another look at their immunity ruling, because even the conservative justices realized we created a loophole that's being exploited way beyond what we intended. Then there's the New Jersey congresswoman case that Bloomberg Law reported on October 23rd. A congresswoman facing criminal charges tried to cite the Trump immunity precedent. She basically argued if presidents get immunity for official acts, then members of Congress should too. And if the definition of official acts is as broad as Trump's lawyers claim, then everything I did as a congresswoman was official, so I should have immunity too. Now, her argument got rejected.
Right now, New Jersey Democratic Congresswoman LaMonica McIver is in federal court where she's trying to get her case dismissed. McIver, you'll remember, was charged back in May for allegedly assaulting federal immigration officers outside a detention facility in Newark. She was visiting there with Mayor Ras Baraka as well as 2 other members of Congress. The mayor was also arrested, but his charges were later dropped. McIver has pleaded not guilty and calls her case attempted political intimidation. She argues the case should be tossed based on grounds of legislative immunity.
Well, let me start with the case on its own merits, because there is a defense that LaMonica McIver's team is using today that could mean that it will be a long time, if ever, before she sees trial. Specifically, her lawyers are arguing that this case must be dismissed on grounds of legislative immunity under the Constitution's speech and debate clause. They are arguing that from the moment she set foot on the property encompassing Delaney Hall, she was exercising her congressional oversight responsibilities. Ali, as you know, there's a statute that entitles members of Congress to inspect and oversee ICE facilities. The argument was she was executing those responsibilities and therefore is immune not only from liability, but immune from having to deal with the trial at all. And if she loses on that motion, we should expect her lawyer, Paul Fishman himself, a former U.S. attorney for New Jersey, to appeal that and say that the case may not move forward until there's a final resolution on the question of her immunity. In that respect, it bears some resemblance to the presidential immunity defense that Donald Trump used in the January 6th case.
Obviously, but the fact that she even tried it made the Supreme Court realize, oh no, we need to clarify this ruling before every elected official in America starts claiming immunity from criminal prosecution. So the court agreed to an emergency review. They didn't wait for the normal appeals process. They fast-tracked it. And on October 21st, 2025, they released a new decision, 5-4. And here's what's interesting about that vote. This wasn't the usual ideological split. This wasn't all the liberal justices on one side and all the conservative justices on the other. The majority included at least one conservative justice who apparently decided, yeah, we went too far with the original ruling. We need to walk this back before it destroys the rule of law. And the decision itself is pretty clear. The court said immunity only applies to core official duties, things that are inherently presidential, things like executing laws, commanding the military, conducting foreign policy, stuff like that. It does not apply to political activities, personal activities, or criminal activities, even if they happen while you were president. The majority opinion specifically says a president cannot invoke immunity as a sword to obstruct criminal accountability for acts undertaken in a personal or political capacity. As a sword, that language is important because that's the court saying Trump's been weaponizing this ruling. He's been using immunity not as a shield to protect legitimate presidential functions, but as a weapon to avoid accountability for crimes. And we're not allowing that anymore. So what does this mean practically? It means prosecutors can now move forward with Trump's criminal cases. And according to Reuters, they're not wasting any time. The election obstruction trial is being scheduled for early December 2025. That's the case about Trump trying to overturn the 2020 election, pressuring state officials, organizing fake electors, inciting the January 6th riot, all of that. And now, with immunity stripped away, prosecutors can argue that none of that was official presidential business. That was Trump acting as a candidate trying to stay in power. That was political, not official. The classified documents case is being scheduled for February 2026. That's the case about Trump taking boxes of classified material to Mar-a-Lago after leaving office and then refusing to give them back. Again, immunity doesn't apply because he wasn't president anymore when he refused to return the documents. That was personal conduct, not official conduct. And there might be other cases too. State cases in Georgia and New York that have been waiting in the wings. Those could move forward now too. Because if federal immunity is gone, state immunity arguments fall apart too. And here's the political nightmare for Trump. These trials are happening right as we head into the 2026 midterms, December 2025, February 2026. Those are critical months for campaigning. Republican candidates are going to be asked constantly, do you support Trump? Do you think he should be president while on trial? Do you believe he's guilty? And Democrats are going to run ads nonstop showing Trump in a courtroom facing criminal charges while he's supposed to be running the country. The optics are devastating, even for his base, because yeah, Trump supporters have stuck with him through everything, but there's a difference between supporting him when he's claiming persecution and supporting him when he's actually sitting in court facing evidence of crimes. Some people will stick with him no matter what, but independents, moderate Republicans, they're going to have a much harder time justifying their support when Trump's literally on trial for federal crimes. And that's the calculation the Supreme Court made here. Whether they admit it or not, the timing of this decision is political. They're releasing it in October 2025, which gives trials time to start before the midterms, but also gives voters time to process what's happening. It's almost like the court is saying, we're going to let the legal system do its job, and then we're going to let voters decide what they think about a president who's on trial for crimes. So where does this leave Trump? Legally, he's in serious trouble. His last major defense just got stripped away. He can't claim immunity anymore. He's going to have to actually defend himself in court on the merits of the cases, and the evidence against him in both the election obstruction and classified documents cases is pretty damning. Politically, he's in a tough spot too, because even if he rallies his base around this as more persecution, more deep state attacks, it's going to be harder to maintain that narrative when he's sitting in a courtroom and prosecutors are presenting evidence. When witnesses are testifying, when documents are being shown to juries, that's not abstract anymore. That's real. That's concrete. And it's a lot harder to dismiss as fake news when it's happening in a formal legal proceeding with rules of evidence and sworn testimony. And strategically, Trump's got limited options. He can try to delay the trials, but judges are going to be less sympathetic now that immunity is off the table. He can try to pardon himself, but that's constitutionally questionable and will probably lead to another Supreme Court case. He could resign, but that would mean giving up power, and Trump never gives up power willingly, so he's basically stuck facing trials he can't avoid, charges he can't dismiss, and evidence he can't make go away. And all of it is happening in the run-up to the 2026 midterms, which makes it impossible to separate the legal from the political. This is the convergence. This is where Trump's legal troubles and his political ambitions collide in the most dramatic way possible, and we're all about to watch it play out in real time. Okay, so let's break down what this Supreme Court decision actually means going forward. Because this isn't just about Trump's legal problems. This is about the future of presidential accountability in America. And depending on how this plays out, we're either going to see a restoration of the rule of law or a complete breakdown of constitutional order. Let's go through this point by point. Point 1. The Supreme Court just saved its own legitimacy. Here's the uncomfortable truth. When the Supreme Court issued its original immunity ruling in 2024, it damaged its credibility badly. Legal scholars, historians, even some conservative judges were saying, wait, this can't be right. You're basically saying presidents are above the law. And for a court that's already dealing with accusations of partisan bias, of being too political, that ruling was a disaster. It made the court look like it was protecting Trump rather than upholding the Constitution. So this new decision, stripping away immunity, is the court's attempt to walk that back, to say we made a mistake, or at least we didn't explain ourselves clearly enough. And here's the correction. And look, that 5-4 vote tells you everything. At least one conservative justice broke ranks. At least one justice who probably voted for the original immunity ruling looked at how Trump was abusing it and said, no, this has gone too far. We need to fix this before we completely lose public trust. Because if the Supreme Court becomes seen as just another political institution that does whatever benefits the president who appointed its justices, then it loses all authority. Nobody respects its rulings. Nobody follows its decisions. And at that point, you don't have a functioning judiciary anymore. You just have 9 people in robes issuing opinions that everyone ignores. So this decision is as much about the court protecting itself as it is about holding Trump accountable. And honestly, that's probably why it happened. Not because the justices suddenly grew a conscience, but because they realized their own power and legitimacy were at stake. Point 2. Trump's trials are going to dominate the next year, December 2025. That's when the election obstruction trial is scheduled to start, 2 months from now. And this isn't going to be a quick trial. This is a complex case with lots of witnesses, lots of evidence, lots of legal arguments. It could take months, which means Trump's going to be spending a significant chunk of late 2025 and early 2026 in a courtroom instead of in the Oval Office. Now, technically, he can still be president while on trial. There's no constitutional provision that says you have to resign if you're criminally prosecuted. But practically, how does that work? How do you run the country when you're in court 3 or 4 days a week? Who's making decisions? Who's handling national security briefings? Who's dealing with international crises? And then there's the classified documents trial starting in February 2026. Same problem. Trump's going to be splitting his time between being president and being a criminal defendant, and his opponents are going to make sure everyone knows it. Every day of trial is going to be front page news. Every witness testimony is going to be analyzed endlessly on cable news. Every piece of evidence is going to be photographed, discussed, debated. This is going to be the O.J. Simpson trial times 1,000 in terms of media coverage and public attention. And all of it is happening in the run-up to the midterms, which brings us to point 3. The 2026 midterms just became a referendum on Trump's criminality. Republicans running in 2026 are in an impossible position now. If they defend Trump, they're defending a president who's actively on trial for federal crimes. If they distance themselves from Trump, they risk losing his base, which is still a huge chunk of the Republican primary electorate. So what do? Most of them are probably going to try to avoid the question. They're going to talk about the economy, immigration, anything but Trump's trials. But Democrats aren't going to let them. Every Republican candidate is going to be asked, do you think Trump should remain president while on trial? Do you think he's guilty? Will you support him if he's convicted? And there's no good answer. Any answer alienates somebody. So we're going to see a lot of uncomfortable, evasive responses from Republican candidates trying to thread an impossible needle. And for Democrats, this is a gift. They don't even have to make their own case against Republicans. They can just point to Trump's trials and say, this is what the Republican Party has become. A party that supports a president who's on trial for trying to overturn an election and stealing classified documents. That's a powerful message, and it's going to be really effective with independent voters who are already skeptical of Trump. Now, Trump's base isn't going anywhere. They're going to see this as more persecution, more proof that the deep state is out to get him. They're going to rally around him harder than ever, but the base alone isn't enough to win elections. Republicans need independents and moderate suburban voters, especially in swing districts and swing states. And those voters are going to be a lot harder to convince when Trump's sitting in a courtroom facing criminal charges. Point 4, Trump could actually be convicted. Here's what people aren't fully processing yet. These trials aren't just political theater. They're real criminal proceedings with real juries who will decide Trump's guilt or innocence based on evidence. And the evidence in both cases is substantial. For the election obstruction case, there are recordings of Trump pressuring state officials. There are emails and text messages from the fake elector scheme. There's testimony from people who were in the room when Trump was planning his efforts to overturn the election. That's not circumstantial. That's direct evidence. For the classified documents case, there are photos of boxes stacked in Mar-a-Lago bathrooms and ballrooms. There are recordings of Trump showing classified documents to people without clearance and admitting he shouldn't have them. There's testimony from his own lawyers saying he refused to return them. Again, that's strong evidence. So there's a real possibility that Trump gets convicted. Maybe not on every charge, but on some of them. And then what? What happens when a sitting president is convicted of federal crimes? We've never been in that situation before. Does he go to prison while he's president? That seems impossible. Do they delay sentencing until after his term? That seems like special treatment. Does Congress immediately impeach and remove him? Maybe, if Democrats control at least one chamber after 2026. But if Republicans hold Congress, they'll probably just ignore the conviction and keep him in office. And at that point, you've got a convicted criminal serving as president. That's not democracy. That's not rule of law. That's a failed state. That's what happens in countries where institutions have completely broken down. And that's the path we're on if Trump's convicted and Republicans just shrug and say, well, we're keeping him anyway. Point 5. This decision sets a critical precedent for future presidents. Here's the one silver lining in all of this. By clarifying that presidential immunity is limited, the Supreme Court has made it clear that future presidents can be held criminally accountable for personal or political misconduct. That's important, because if the original broad immunity ruling had stood, it would have fundamentally changed the presidency. It would have meant that anyone who becomes president essentially gets a free pass to commit crimes as long as they can claim it was part of their official duties. That's how you end up with authoritarian leaders who can't be removed or punished no matter what they do. So this decision, even though it's coming too late to prevent a lot of Trump's damage, at least prevents future presidents from having the same unchecked power. It reestablishes the principle that no one is above the law, not even the president. And that's crucial for the long-term health of American democracy. Whether it's enough to save us from the immediate crisis of Trump's presidency remains to be seen, but at least it's a step in the right direction. So where does all this leave us? We've got a Supreme Court that just stripped Trump's immunity. We've got criminal trials starting in December and February. We've got a president who's going to be splitting his time between governing and defending himself in court. We've got the 2026 midterms turning into a referendum on whether America wants to keep a criminally prosecuted president in power. And we've got the very real possibility that Trump could be convicted of federal crimes while serving as president, which would create a constitutional crisis unlike anything we've seen before. This is not normal. This is not sustainable, and something's going to break. The question is, what breaks first? Does Trump get convicted and removed? Does he resign to avoid conviction? Does Congress impeach him? Do Republicans lose so badly in 2026 that he becomes a lame duck? Or does he somehow survive all of this, consolidate even more power, and drag us further into authoritarianism? We're going to find out soon, because these trials aren't some distant future possibility anymore. They're starting in 2 months. The evidence is going to be presented. Witnesses are going to testify, and juries are going to make decisions that will determine the future of American democracy. So yeah, this Supreme Court decision matters. It matters more than almost any other political story right now because it's the thing that determines whether we're a nation of laws or a nation where the powerful can do whatever they want without consequences. And we're about to find out which one we are. All right, that's the breakdown. If you made it this far, you understand how significant this is. Hit that subscribe button. Drop a comment with your thoughts. Do you think Trump will actually be convicted? Do you think he'll resign? Do you think Republicans will finally turn on him if he's found guilty? Because honestly, I don't know, but I know we're living through history right now, and not the good kind of history, the kind that future generations are going to study and ask, how did you let this happen? So let's make sure we're paying attention. Let's make sure we're holding people accountable. And let's make sure we don't look back in 10 years and realize we missed a moment when we could have saved American democracy. All right, that's it. See you in the next one. Stay vigilant.